Hi AI class, it's Professor Opterbeck, and in this video I want to give you some thoughts that I'm thinking about in terms of AI and product liability. And when we talk about AI and product liability, we're dealing with this axis of AI regulation concerning accountability. So if something goes wrong, who's going to be responsible for that? How are people injured by it going to be have a remedy and be compensated? And when we're talking about accountability, we're also talking about deterrence. So can an accountability regime drive compliance, make the product safer, and deter some conduct that might be a problem? Now, in my cover slide here, you see I have this kind of meat grinder, and there are two reasons for that. One is that old saw that, seeing how laws are made is like watching sausage being made. You don't really want to watch it. And I do think as we go through this, and especially as we talk about what's happening in the EU, you'll see that there is a bit of sausage making going on. It's also because my thinking about this is kind of what in the scholarly world we consider raw meat. I haven't published anything on this yet. I haven't even written any kind of comprehensive draft on it yet. But I have been speaking with some other scholars at various conferences and working on my thoughts on it. And it is something that I hope in the next year or so to be writing some scholarship on. So here are some thoughts, and here are a few scenarios that could come up when we're thinking about AI and product liability. Now, the one area that I've got here kind of in the middle is the sort of thing that a lot of people have been thinking about for quite a while, because self-driving cars have been on the market, or cars with at least aspects of self-driving components have been on the market for a while now, and we already have seen some accidents involving self-driving features of cars where the claim is that something went wrong with the self-driving feature. And this also is an area in which kind of traditional ideas about torts and product liability are really intuitive, because we've got a very long history with tort law and auto accidents. We have, in most states, systems of no fault as well as fault-based systems. We have insurance, so we have a lot of experience with that. It makes a lot of sense. And I'm interested in that topic, but I want to think more broadly about some other things. So, we've talked quite a bit about potential biases in AI systems, and so what if a bias in an AI system ends up in a decision that precludes somebody from some benefit, like a credit decision? There's a harm there of being precluded. What if an AI system like a chatbot is, here's another example, right? What if an AI system like a chatbot is giving recommendations to people and is kind of giving health hacks, like you might see on someone's Instagram or TikTok feed, and it's AI generated, and it's actually something that ends up being harmful, and some people end up following it. And we already also have a couple examples of people following recommendations of chatbots that were harmful, or really interestingly, frighteningly, but interestingly, people buying on Amazon AI-generated self-published books on health topics that give bad advice, and following that advice and being injured by it. Here, the thought is about a AI-enabled or AI-assisted medical device. I've done some scholarship on this already, on the regulatory framework around medical devices. Regulatory agencies are thinking about this. In the U.S., the FDA regulates medical devices and pharmaceutical drugs and biologic drugs. But if something goes wrong in the marketplace and people are injured, there's a somewhat complicated question about whether there's federal preemption over a tort claim. In very many cases, there is not federal preemption over the tort claim. The approval process will be part of sort of the assessment of whether the product was unreasonably dangerous, but it won't necessarily bar the claim. So here's an example of some kind of medical device, using AI learning that goes wrong and injures someone. And again, here's an example of a biologic treatment. In this case, it could be a pharmaceutical drug or a biologic treatment. And this example, I'm thinking about traditional large molecule pharmaceuticals, which generally are not tailored to an individual condition. So and AI is already being used for something called high throughput screening. So the drug companies are trying to find candidate molecules that have a certain effect that there's a hypothesis would do something in the body that would benefit some condition. And traditionally that was done by human researchers, but to be able to put this through very quickly and at least kind of whittle down the potential chemical compounds could be helpful. And that's one area, and that's kind of the small molecule pharmaceuticals. The large molecule or biologic treatments are a new domain, and there's a lot of potential promise in the technology of biologic treatments of being able to tailor the medicine to an individual's genetic makeup and history and biology. So what if there's and that of course is a very difficult, time-consuming process, and kind of on a macro level, a societal level, to ensure and pay for that would be extraordinarily difficult. But what if that was able to be done much more quickly and much more efficiently using AI? A really interesting potential promise for the technology and really beneficial. But what if there's a specific treatment that is tailor engineered, but it has some unanticipated side effects that really hurt certain people or hurt certain people with co-indications, other related illnesses or so on. So all of these things, and one thing I tried to do, and there's many other like this we could come up with, but I'm trying to come up with a sort of flow that says there are reputational injuries, right? There are financial injuries, and there are physical injuries. Now, one of the things about traditional product liability law and tort law in general, as we'll go through here, is that it's historically designed to deal with personal injury and property damage. It's not historically designed to deal with things like harm to a reputation, to deal with mere financial losses. And, mere is kind of a loaded word here, right? But if you're denied access to credit, the law, Anglo-American law, tends to see that as, well, it's a financial harm, right? So it's not really, and mere emotional losses. And again, mere is a loaded word there. Tort law does deal with emotional harms, as you know, but traditionally and most typically in the context where there's an emotional harm that can be connected with a physical harm. You're in a car accident, you suffer some physical injuries, and then subsequently you also suffer post-traumatic stress disorder, right? And you can recover for those emotional distress harms in that context. There is some law in some contexts where you might be able to cover for purely emotional distress harms without accompanying physical harm, but that's still relatively limited in American tort doctrine. And so the question of whether these emotional, reputational type harms, as well as economic harms, is one that tort law might have to adjust to if some of these other scenarios might come into play. When we're trying to conceive of AI in a product liability context, one of the difficult things is conceiving of what sort of product we're dealing with and how that and what sorts of things can go wrong and how that product might fit into our traditional frameworks. And to do that, we really need to step back and think a little bit again about how AI works. And I'm not going to spend a lot of time on this because we've talked about these things throughout the class and we've read a whole bunch of material, and so you should have a pretty good sense of this. But here's an example of a convolution network that is taking, and this is just a very kind of abstract representation, but it's taking pixel data off of pictures. It's algorithmically reducing those to certain kind of predictive weights, right? And through iterations of the algorithm, it can come up with a relatively small number of predictive weights that can predict, all right, what am I looking at? Is it a city, right, or is it a beach? And So this is what we do in our human brains, really. We're looking at this picture. How do we know this is a beach? Well, we see this kind of light brown stretch. We see this blue stretch with this kind of white piece here. We see these brown things with the green, right? And the blue here with the white. And we've got representations, and we don't fully understand how this works yet, but we've got kind of chemical nodes or predictive things within our brain that are allowing us to rapidly say, that's likely a beach, right? That combination of things in those proportions, and contrary to that, right? This is likely a city. These colors, grayish, brownish, pointing in these directions. A similar kind of thing here. What this predictive system is doing. Here's just a graphical representation of a neural network. And if you remember this, right, where the system is taking tokens from the training information, and it is looking again at predictive relationships among those tokens. It's creating predictive weights, and it's coming up then with a smaller number of things from which the system can make a decision. This is the output layer that's going to then give the decision to the user, but these layers in between are hidden in the sense that it's very difficult and sometimes even impossible to know exactly how these different weights are being created within this vastly complex structure based on often this is used in large models, a large amount of training data. All right, so this again just an example. Now, when we translate this into kind of the real, that's sort of the abstraction of how the system works. Very kind of light abstraction of how different kinds of AI systems work. We translate this into the real world. What is needed to create, select, and train an AI model? And here we start to talk about the AI technology stack. The idea of the AI technology stack is that there are a bunch of different things, right? A stack of different things that are going into the creation of the training and creation of that model. And the representations I'm going to show you here, once again, are kind of simplified. It would get a lot more complex, but I think they're pretty representative. So, a large language model, for example, we have inputs that are training data. So we have some corpus of training data. The training data can come from a lot of different sources. It can be synthetic data. It can be actual data. It can be open source data. It can be closed source data in the sense that it's proprietary to the entity that's training the model. It can be public or quasi-public data, for example, data on the internet, and we'll just set aside, bracket off copyright and other concerns like that for the moment, right? So there's a lot of ways in which we get these inputs. Now, the training data, doesn't sort of just like go into the model whole cloth. It's not like a large language model stores an exact copy, PDF files of all the training data. A copy is made, data is extracted, and that data is tokenized, right, is broken up into smaller parts, and it's those smaller parts that are then ultimately going to be fed into the model. So there is, before we even get into the model itself, there's this code layer. Now, something you might analogize a little bit if you've taken the cybersecurity classes, and we've talked about that layered model of the internet. We have the somewhat more complicated OSI 8-layer model, but simplified in kind of internet law and policy. We often talk about the hardware layer, the code layer, and the content layer. Think kind of analogously, somewhat similar to that, right? We have inputs, some data, some content, and then there's a code layer of how is that content being extracted, say like through a Python script or something, and then how is it being put into tokens. And that code layer has multiple sources as well. Some of that can be open source, some of that can be proprietary, often a mix of the two. There also are often going to be application programming interfaces, which is not the code that's doing the work, but the code that's allowing the code that's doing the work to interact with the operating system that you might be using, whether it's Apple or Windows or Linux or whatever kind of operating system you might be using. And right, so a stack of code. All right. Then we have the model and the refinement of the model. So the tokens, the things that are being abstracted from the training data are then being, put into a model which is some initial set of algorithmic conditions that is allowing the weights within the model to be affected by that training data and to be iteratively affected, right? That's what we mean by learning. As more training data comes in, those algorithmic weights, those predictive weights are going to be refined and refined and refined. So we have usually again, a simplified way of thinking about it, but a good way to think about it, right? Usually within training an AI model, you have some initial foundational model training, and then you have refinements before the model is released, which may involve additional training data, and or it may involve taking the kind of raw training data and structuring it and tagging it, right, to give more specificity to the model. So when this is happening, right, what the model is and how the model responds to the training, again, has a code layer. And the code layer, again, is going to be potentially proprietary, potentially open source, potentially a mix of both, and potentially have APIs that are allowing that to talk with the operating system and everything else that it needs to interact with. So then we have a model, and the model is producing some outputs, right? If it's a language model, then it's producing text, and the text is just, the model predicting which words and numbers and so on, which characters are going to follow after each other. Or, if it's a financial model of making mortgage decisions, it's producing an up or down or a rating or something like that on the mortgage decision. So that output is coming to the user in some format that the user, can read and can use, and there's a code layer there as well. And again, that can be proprietary, can be open source, and it's likely going to have APIs that are communicating with the operating system to translate that to the end user. So what I want you to take away from this, there's 1, 2, 3, 4, 5, at least 5 sort of inflection points in the selection and training of the model, and each of those inflection points has multiple layers of code and other things that are going to go into it, which means multiple layers of potentially entities involved and multiple places at which there could be some kind of fault, whether it's a design fault or what would be analogous to a manufacturing kind of flaw, whether it's a need for some kind of safety on it, whether it's user error, right? Multiple sort of levels for it. And in a moment, we're going to compare this to a more typical example, which would be a broken lawnmower. All right. Now, so this is the model selection and training. And when we're thinking about AI compliance, kind of the frameworks we think about are the entity that's going to be, deploying the AI, perhaps creating it and then deploying the AI is, well, what model do we want to use? Are we creating a model? How are we doing that? How is it refined? And now we're going to have a process that's going to take some time, and at some point we're going to say, all right, now this is ready to be deployed, and we're going to use it, whether it's within our own enterprise or, as a product that's put out to others, or we might say we're not going to use it because it's never going to be good enough. But let's assume, right, we're going to use it, and that's where the model is now in operation. And when the model is in operation, if it's a learning kind of model, which is usually a feature of the models that we want to use and release, we've still got ongoing process of refinement, right? So we've still got that going on. But notice here that now we've got another aspect of inputs. So when we looked at the model selection and initial model training, we've got training data. Now we've got user queries, right? User prompts. And as you know, if you've interacted with some of the big public open models like ChatGPT, your prompts are not proprietary to you. The terms of use are going to say that your prompts are being used by the proprietors of the model to make the model better. And so prompts are now another form of input. So all of the vast users who are involved in their prompting might be affecting ultimately the kind of outputs the model is giving. And in this phase, in a compliance sense, and one of the things that any liability regime would want to incentivize is that the proprietors of the model have some responsibility to be monitoring how the model is changing as it is being used. It's there's a phenomenon called model drift, where from what the model was originally doing and maybe doing well when it was released, it's drifting and doing something different. It can be a bit opaque as to why that can happen, but one reason it can happen can be the kinds of prompts that the model is getting. This may be totally innocent. It might just be kind of a feature of the randomness of the large number of information and the way users are using it. It can also, as we've seen, be malicious, right? There are ways of doing prompt engineering to make a model do something that it's not meant to do, as well as to poison and break a model. All right, so you got inputs from many users. Again, you've got on the input side, the user is going to have some kind of interface. It may be real simple, like just a web page with a text box and some buttons, like these open models. It may be a little more sophisticated, but whatever it is, right? There's a code layer, could be proprietary, could be open source, going to have some APIs, right? Then within the model, as how the model is set up to be refined as it is responding to user prompts, and then as the producer or deployer of the model might have the ability to have some human oversight and to maybe do some retraining or adjust weights and things like that. And again, we're going to have a layer there. And then the outputs to the user, this might be the same interface as this, or it might not, right? Depends on how the training environment is set up and how the user environment is set up. But in any event, we have another stack. Pretty complicated, I would say, from a traditional tort and product liability perspective. Here's one example from this group of a way of thinking about the AI stack and the entities that may be involved in providing the AI stack, all the way from the programming language that it's used in, something that we don't think about often, the data storage of where the aspects of the model are stored. A really important thing, and we've actually talked about it recently in our discussions about the AI divide and the effect of large AI models on the environment and things like that. We're talking about the vast data storage requirements and network requirements of large AI models, and how basically hyperscalers, Google and Amazon and so on, are providing a lot of that infrastructure. Right. So we've got that, databases, other sorts of things, right? All of these involve different entities. Here, again, by that same organization is a nice kind of graphic visualization of different entities that might be involved in that whole process. Right, so this the entity that's putting this out is this Mongo database. So they're selling their product, but they're just showing here's where we fit. Right. Notice right here's your base programming languages like Python. That's going to be a scripting language to extract data and extract tokens, and then you might be taking a foundation model from a third party and refining it. You might be doing your own as well, right? But here we see some of the big ones like OpenAI, Hugging Face, which is Google, right? Meta, right? Some of those. Then you've got frameworks that are going to, bring all of that together, and you can see some of the providers that do that. Entities that provide tools to help with monitoring. You've got entities that do that, right? And then our deployment, our infrastructure, as we just mentioned, basically some of the hyperscalers like Google and Amazon and Meta. All right, so this will give you a feel, I hope, for the somewhat complexity of the process and all the different entities and elements that can be involved. So when we think about accountability for all of this, one way to think about it, and really the primary way that we've thought about it throughout the whole term, is some kind of direct regulation. So some government entity or set of entities would establish some kind of principles and standards. And if you violate those principles or standards, then you are going to be liable for injunctive relief and or for some kind of penalty or fine from that government entity. And that's the primary model behind the EU AI Act. So all of the things we've been talking about, prohibiting some uses, having these various things, requirements that we have to have for high-risk systems, is a way of direct government regulation. And in regulatory theory, when we're thinking about in economic terms, the externalities, the harms that a system might throw off that will affect third parties beyond the users, and or direct harms to users, this is one way of doing it, but it's only one way. And another way of thinking about it, a complementary potential way, is to say that when there is an actual injured party, right, they have a claim for relief, and a civil claim for relief, and that civil claim for relief provides them with a liability rule, right? Provides them with some kind of damages for the harm that they've suffered. Maybe it provides them with a kind of property rule where there's some injunctive relief, but usually it's a liability rule. There's some kind of damage. But the prospect of those potential damages, the theory goes, then will drive further compliance and further improvements, because nobody wants to be faced with damages of that sort. So traditional product liability is a risk spreading, an insurance mechanism, and an incentive mechanism in economic terms. And as I alluded to before, a classic example, a kind of case to think about, is a lawnmower. So you see this guy in this picture sticking his hand in the bottom of the lawnmower where the blade is in order to get clumps of grass and things out of there so that he can continue to mow his lawn. And now if you're going to make a lawnmower with a blade, a metal blade that spins around, that blade is more than capable of chopping off someone's fingers or hands or mangling their foot. And there are many, many cases of those kind of accidents. At the law firm I used to work at, there was a guy that did tons and tons of lawnmower cases. It happens all the time, right? So now, thankfully, in this picture, it appears that the lawnmower has been turned off, right? So the blade is not spinning. Now, it's necessary to the lawnmower's use that it have this blade, which is potentially dangerous. Then the question is it inherently dangerous or unreasonably dangerous? And what should the law do to say, well, is there an alternative to using a dangerous spinning blade? And or are there safety devices that could be put on so that the blade could be there but someone's hand couldn't be stuck in there? And or are there safety devices that could be put on to say that if you turn the lawnmower on its side, it turns off and the blade stops? And or is it really the case that you maybe can just give a set of warnings and instructions, and users have to have a little bit of common sense to know not to stick their hand into a spinning blade, but you've at least given some instructions, right? So all of these sorts of things go into the question of product liability for a lawnmower. Now, the thing with a lawnmower is it's a relatively simple product. When you look at this thing, right, just a metal blade and a round housing. The thing spins around. It's got some wheels, and it's got a little simple two-stroke engine. And that's it. Super simple device in terms of engineering and in terms of kind of the stack, the technology stack, right, of putting this device onto the market. So, you're going to have at least a manufacturer who's making the product. Now, you might have, you probably will have parts suppliers. I'm just going to put parts right here, who are, maybe stamping out the metal blades or stamping out the wheels or doing other things, and they might have some responsibility. But you got a manufacturer designing the thing, putting it together. There's a distributor who's got some network in which they're putting it out to retailers. And then the distributor might either be selling directly to consumers, or there might be kind of a retail layer here, right? And then the consumer. And then in this, 2 or 3 or 4 at most kind of layers, there are contractual relationships. And so we could say that these contractual relationships should really define the scope, if any, of the responsibility and liability among these parties. And that really, before the advent of products liability law, was the traditional rule. So as the consumer, you might have contractual privity with I'm just going to put R here for a retailer, or maybe directly with a distributor, right? And then, whatever your contract provides or doesn't provide about limitations of liability and warranties and representations about the safety of the product and warnings and so on, whatever that provides, it provides. Whatever it doesn't, it doesn't, right? And then if you as the consumer don't have contractual privity with the manufacturer, which you usually would not, you don't have a claim against the manufacturer. That's the traditional rule before product liability. Product liability then changes those rules by doing away with the need for contractual privity and by imposing joint and several liability among every entity in the chain, in the stack, right, that is causing the product to come eventually to the consumer. So why would you impose joint and several liability? And joint and several means the consumer can sue the distributor or the manufacturer, or both, and obtain from any of them the full damages from losing your fingers when the thing doesn't turn off when you turn it over, right? If that's your claim. In economic terms, there's a couple reasons for this. One is simply the ability to spread risk so that the injured person has some kind of remedy. So, if the distributor doesn't have assets, hopefully the manufacturer does, or vice versa. Further, it drives insurance. So now if everyone in the chain who's making this product knows that there's some prospect of this joint and several liability, they're going to be procuring insurance to cover that risk, which spreads the risk and provides resources for the injured party. Further, it's going to drive compliance in these contractual terms between the B2B parties, right? The distributor and the manufacturer and a parts manufacturer and a retailer or whatever it may be. So among those parties, there are going to be limits of liability and representations and warranties and requirements to have insurance. So the whole system, by imposing this liability, drives a system of compliance, a contractual system, and an insurance-based system. Further, it invokes or it helps trigger something called the least cost avoider principle. And the idea here is that whoever in this chain is able with the lowest cost to mitigate this risk should have the responsibility to do so. Now, in a simple product like this lawnmower, that most of the time is going to be the manufacturer. So the manufacturer, I'm just going to put LCA, is usually the LCA for a simple product like this because they're the ones who knows how to put together. They're the ones who knows, okay, if I add a kind of kill switch that turns the machine off whenever it's turned over, or if I add a metal plate that keeps someone from sticking their foot under it while it's moving, I know what that costs. I know how to do that. It's easier for me to decide to do that, and then I can pass on those costs down the chain. It's harder for the distributor to inspect, and they're not going to have the expertise and whatnot to inspect every unit and make those decisions. So the least cost avoider says, in the traditional way of looking at it, the consumer doesn't have contractual privity. The manufacturer might not take that step. So these are some economic reasons for product liability regime, starting in the 1950s or so, that begins to replace the contractual privity restriction. Within product liability law, as you have looked into some aspects of how product liability law is developed, you see that there are a number of different sorts of claims that you can raise. There can be a claim about the design of the product. The design is just faulty, and so you should have designed it, with the kill switch, or you should have designed it with the guard around the side. So you can have a claim like that, and those kinds of claims are often going to be a kind of cost-benefit analysis. How much would it have cost for a reasonable alternative design? There can be cases of manufacturing defects. So it might be that the product is designed well, but it happens that in this particular one, there was a manufacturing flaw in the blade that caused a weakness in the metal of that particular blade in that particular unit. And so that particular unit, when it was going over the ground, the blade shattered and a piece flew up and hit the guy in the eye, right? That wouldn't have happened with most of these units. So that's a manufacturing defect. That's a possibility. There are also warning-based claims. So you get into a product like this, it has some inherent dangers. And under product liability law, you're going to have some obligation to provide instructions for use to the user that tell them, here's the proper way to do this. And if you've ever read the instructions, for something like a lawnmower, somewhere there will be a big box that says something obvious in large type, like, do not stick your hand in the blade while the motor is operational, right? And you read that and you're like, well, of course not. But that's a kind of warning. And instructions for use, we've seen that as a direct regulatory thing in the EU AI Act. So you've got that kind of basic system. What you end up also having in the actual litigation context for many kinds of products. Now, this will get outside the lawnmower case. I think lawnmower cases, tend to be one-off, relatively simple, not class action cases. But get into something like a claim that a pharmaceutical product has a manufacturing or design defect, effectively, or has warning defects. The warnings don't tell the doctor and the patient enough about drug interactions. All those sorts of things are typical product liability pharma claims. And that's the kind of product that gets out there to a large number of people, and that's where you tend to have class action, toxic tort type class action litigation. Asbestos cases, product liability cases, and so on. So when you have the class action dynamic, it introduces a sort of new level to the way that tort law might, in a regulatory sense, affect deterrence and compliance. And here I've got sort of little check boxes, meaning there's many thousands, maybe even millions of individual potential consumers. Product liability itself would function in the same way substantively, but what you're going to end up producing are class settlements. The class settlements are going to very often in a toxic tort or pharmaceutical type product liability case set up some kind of claims mechanism, a mini kind of arbitration in which claimants will make out what their losses might be, and then may recover something from that process, and or may get some direct benefit, monetary or otherwise, out of the settlement. And then, of course, there's always a fee to class counsel. Of course, in a typical individual product liability case, the plaintiff's counsel usually is on a contingency and takes a third as their fee. In a class settlement, there's there's different incentives and there's a court-awarded fee. It just creates a different kind of dynamic, and a lot of this will depend on how you feel about the class action mechanism as a regulatory tool. I will say that in some settings I'm a little bit skeptical of it, but in some settings I think it's sort of the best available tool, perhaps. A lot of it is going to depend, but how all this would map onto that AI product liability stack. But how all of this would map onto the AI technology stack is really the point of this discussion. I'm not really sure. If you take all of these boxes and now we've got to add those 7 or 8 different layers, at least 3 or 4 different inflection points at the place of the AI model creation and deployment, and then at the place of the AI model being in action and used by an end user. It becomes, I think, really difficult to see how these functions, who would be the least cost avoider, not entirely clear in every case. It's a bit easy to say, well, all right, if it's OpenAI or if it's Meta or Google, they have big resources, they're the least cost avoider. Maybe they are, maybe they're just the best resourced party that maybe we want to put liability on them for that reason, or maybe not, right? So, how all this would work, I just think it's an interesting open question, and I'm not sure. The other kind of related question to this is that a lot of what we're dealing with AI is software. Not all of it is code in the sense of the traditional idea of computer object code or source code, where some source code, some coders writing in a coding language. Some of it is, right. The interfaces and other things like that are. Some of it is sort of other kinds of software or code analogous things, which is the weights of the model, those algorithmic weights and things that happen in the model. And in traditional tort law and product liability law, we've had difficulty deciding, is software a product? Is it a product for the purpose of the Uniform Commercial Code for the contractual, what the contractual terms mean, or is it a license of intellectual property and services, in which case there's a different result under the Uniform Commercial Code and potentially a different result for product liability, because if the issue is that it's a license, well, then those issues of contract and privity become salient again. But if we define it as a product or as some kind of hybrid, right, then product liability might kick in. And those doctrines are developing. There are cases that both in the UCC context and in the product liability context that suggest software indeed can be thought of as a product. And there are cases that go the other way. And that's kind of an open question too as to how this framework fits. Now, as usual, the one place that is already enacting some law for better or worse on this is in the EU. So the EU has recently adopted a general revised product liability directive that has to be implemented by the member states by December 2026. Recall that a directive is a form of EU lawmaking that sets some basic standards, and each of the EU member states then is enabled to and required to enact national law that is supposed to be consistent with those standards. But the idea here is that there is room for variation within the framework of the directive's standards of the national law, in contrast to a regulation like the AI Act and like the GDPR, in which case the EU sets the one standard that applies uniformly across the member states. So this is a directive, but it does have some basic standards that are interesting. And one of the most interesting is to make it clear that software is a product for the purposes of product liability in the EU. And most observers think that this is going to include AI systems, or at least major components of AI systems. I'm just going to kind of bracket, I do think, and this is something I want to do some research and writing about, that there is an open question about whether the model weights are really software as defined under the Product Liability Directive. And in a moment, we're going to look at another directive on product liability and AI, which the EU, in fact, did not adopt, and which seems to be dead. So anyway, at least software, and that probably includes, if not all AI systems, at least components of AI systems. The other really important development here is the definition of damage. And you will see that the Product Liability Directive specifically includes things that are not traditionally included under tort law, at least under common law-based tort law. So we'll include physical and property damage, but also is going to include mental health claims as such, and also is going to include loss and corruption of data. So the mere loss and corruption of data now is going to be a cognizable harm under EU product liability. There's a debate among privacy scholars in the United States about whether harms such as this are cognizable in tort claims, particularly harms to loss or corruption of data as such. Many privacy scholars in the U.S. believe that there are trends in the common law of privacy and in privacy statutes that suggest that there already is and that there should be these recovery for these kind of harms in a tort context. As I often find myself, I'm a bit of an outlier here and have written where I'm a bit skeptical of that. As I see it, the trend is not toward allowing these kind of independent harms in the tort context in general, and I'm not totally convinced that it would be the right development, broadly speaking, in the tort context, but you can look at that scholarship if you're interested in that. In any event, here in the EU, they have quite clearly included that. So this is certainly going to cover at least some kinds of harms from AI systems, but it's not clear to me that this will cover every AI system and all of the kinds of harms that we mentioned at the beginning of this video. The directive also defines what a defective product is, and this is a pretty broad and somewhat vague definition. It's not the way it would be formulated exactly in American product liability law. So it doesn't provide the safety which the public at large is entitled to expect. Now, there is a list of factors which is pretty familiar to us as American lawyers. What are the instructions for use? How is the product likely to, foreseeably to be used? How might it be misused? What safety features are there? So all that's pretty common. I think some of this language about what the public is entitled to expect, when we looked at the categories of prohibited products and of highly risky products in high-risk products in the EU AI Act, remember that it referred to those annexes to the Act. It listed certain things, but then it also referred to other EU product regulatory frameworks. And so this is reflecting that in the EU, there are directives and regulations that cover sort of all of these categories of products. So think of something like lawnmowers in the EU. There will be a directive or a regulation that has technical specifications and other things at the EU level for lawnmowers. We really don't have that in the US. We do have things like the Consumer Product Safety Commission or NIST or other engineering bodies that publish standards, and those standards often become relevant to what the duty of care might be in tort in a given jurisdiction. But our tort concept tends to be a sort of bottom-up look at what is reasonable, rather than a kind of top-down regulatory domain, where in Europe it tends to be more of starting with that top-down regulatory domain. So I think what some of this is about is, well, is there a relevant regulatory standard? Now, for AI, now of course we do have one. We have the EU AI Act. So presumably there are things in the EU AI Act that relate to what's called safety here. And again, what does safety mean in the AI context? But that relate to this and that the public is entitled to expect. Notice also specifically cybersecurity requirements are mentioned. And now this is going to tie to this idea of damage, including loss or corruption of data, which connects with the EU view of privacy, right? So you have to have security to have privacy. So in the EU, a data breach, a traditional data breach, AI or not, in which there's a data loss, is going to give rise potentially to, it'll give rise to a claim, and then the question will be kind of causation, right? Whereas in the U.S., a traditional data breach, sometimes courts will allow them to proceed. Sometimes they won't, based on whether there's a concrete showing of harm connecting with standing and other things. Right, so here's the burden of proof. Here's where I mentioned those regulatory standards, and here's a more general kind of quasi-negligence based standard. And you'll have to ask questions about what is an obvious malfunction, what is normal use, what are ordinary circumstances. Not that hard, again, to see with a lawnmower. If the blade breaks and it hits somebody in the eye, going to be much harder to specify with AI. Now, because of these kind of challenges with AI, the EU has been considering for a couple of years an AI liability directive specific to AI. Now, the general product liability directive was adopted. This AI liability directive was not. It faced some opposition from industry and some other questions. It's been tabled, and as far as we can tell, it doesn't seem like it's going to be something that's going to be brought back. But if you look at it, you can see, I think, some of the reasons why this is difficult. So it would have said the AI Act establishes a duty of care. I think that's already going to be true under the Product Liability Directive. But notice that it would have created a rebuttable presumption of causation. Causation is going to be a real difficult issue when we've got that complex technology stack, and we're trying to figure out, when it's relatively opaque, why was a certain decision by the system made, and is that a fault, and who caused that fault, right? So this would put a presumption of causality if the fault, the alleged fault, has influenced the output. Now, this caught my eye when I was first looking at it. I have no idea what the word influenced is supposed to mean here. It wouldn't be enough, I don't think, under Anglo-American common law to establish but-for cause, much less foreseeable, much less proximate cause. So it seems to me to be a broader concept, and to, again, kind of throw the onus back with the rebuttable presumption on the creator and deployer of the AI system. That may or may not be a good idea, but this is also one of the reasons why there was some pushback. What does this kind of thing mean? Now, again, this has not been adopted, but it just raises the question of, what does causation mean when we're looking at that whole complicated stack? Who are we going to actually hold responsible? And then, claim for damages would include compensation for the system to producing a bad output or not producing an output that should have been produced. So just a few thoughts to kind of wrap up this video. The question of software and product liability, as we see in the traditional difficulty in the U.S. of whether it's a product or not, and the law that's developing on that, contrasting to Europe, where it now clearly is. How does that work? My sense is that we're not in a traditional manufacturing economy anymore. Of course, we still have those rules for things like lawnmowers, but even things like lawnmowers are starting to become smart devices. Certainly cars are, right? So in that world, it seems to make sense that you've got to extend a notion of product to software and to AI models. What kind of standard would we apply? In U.S. law, product liability traditionally was traditional strict liability, but it's become more and more fault-based, even within strict liability. So how would you do that? How would you decide things like causation, which was a big problem in the EU draft for the AI product liability, and how would we do that in a common law setting? And of course, we have related to this. It doesn't have to be mutually exclusive, but the possibility of some kind of broader regulatory framework with regulatory penalties and so on. But how does that work? And we've been talking about that with the AI Act all semester. How do the standards work? Can we have standards that are not too vague, that relate to the technology? And if it's going to be regulated in that way, how do we avoid the problem of the industry simply capturing the regulatory body? All of these are open questions for research, and I think a domain that's going to develop in very interesting ways in U.S. law as cases are going to be litigated in the coming years.